If you've been charged with domestic violence of any kind in California, there is one thing that you absolutely need to know if you are still living with, dating, whatever, if you're still with the alleged victim. And in this video, I'm going to be telling you exactly what that is so that you can be prepared. My name is Veronica. I am a criminal defense attorney here in California, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be telling you if you are still with the alleged victim in your domestic violence case, or maybe it's your child and you're still obviously living with your child, maybe it's your spouse, whatever it may be, I'm going to be telling you about what you absolutely need to know before your first court date so that you are not unpleasantly surprised. So let's get right into it. At your first court date for any type of domestic violence case, any kind of violence against a family member, somebody you live with, somebody you're dating, ex, whatever it may be, the prosecution is going to ask the judge for a restraining order. And the judge likes to grant these restraining orders. But there's one thing that you absolutely need to do to make sure that that doesn't happen, which is have the victim show up and speak to the court. If it's a child, have the other parent show up. You need the alleged victim to speak to the court and tell the judge three things. Number one, that they are not afraid of you. Number two, that if anything were to happen, they would call 911. And number three, that they want the protective order to not be put in place, or they want a level 1, which basically means that you two can have contact, but you cannot harass, strike, do any of that stuff that you're not supposed to do anyway against them. That is absolutely necessary. Now, there are other things you can do, like you can take domestic violence classes before your first court date. But if the victim does not show up and say, hey, I don't want this restraining order to be in place, they're going to slap you with a restraining order that will make it a crime for you to go back home if you live together, for you to drive in the car together, for you to parent your child together, whatever it may be, for you to have your normal family life. So I've had people call my office who are not my clients after their first court date, call me from court, either in tears or just really freaking out, saying, what am I supposed to do? I don't have another place to stay. I can't afford, I just bonded out, paid $5,000 for that. I can't afford to pay for a hotel every night. It doesn't make sense for me to get another apartment, and I just got slapped with this restraining order that's saying I cannot even go back to my home. And maybe the alleged victim is at home just waiting to hear what happened at court that day. Maybe they're at work and they couldn't make it that day, or they didn't think that they needed to, because nobody tells you these things. But it's really important for everyone to know, if you are still together, absolutely have the victim come to court. If you have a public defender, have the public defender make sure that they know that the alleged victim's here and they don't want a restraining order. And it's their job to say, and same for your private attorney, to say, Your Honor, the victim would like to be heard on the restraining order. And restraining order, protective order, that's all the same thing. Typically, I will let the prosecutor know ahead of time. They can speak to the victim. That's their right. Of course, the victim will say, hey, I don't want this restraining order. That's pretty much it. That's all that you're going to talk about. And the prosecutor will probably say, I don't care. I'm going to ask for one anyway. That's what I have to do. That's the policy. And then when you're in front of the judge, the defense attorney needs to give the victim an opportunity to be heard. We cannot count on the DA necessarily to do this, because they're the ones asking for the restraining order. And from there, that gives you your best possible shot at getting this dropped. Without this, they will issue the protective order. So make sure that the victim shows up on that day. If you're the victim, make sure that you show up on that day. And if you're the victim, obviously, the person who has been arrested needs a defense attorney, and that's priority. But sometimes you actually want to hire an attorney yourself. Usually it is a criminal defense attorney, to make sure that you know all these things, to make sure that you are heard, to make sure that your rights are actually being met and not being overridden by the court or by the prosecutor. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation directly with the link right there.